This podcast is brought to you by the School of Advanced Study, University of London. All of our podcasts are available from our website, www.sas.ac.uk.
Well, a very good evening to you all, and it's my great pleasure to welcome you to the last in the series of International Refugee Law seminars run by the Refugee Law Initiative for this academic year. For those of you who already feel the pining for more, I can assure you that we have a further set planned for next year from October, so look on the website and we should also be sending around email details of those. Having said that, this evening it's my very great pleasure to present Professor Geoff Gilbert of the University of Essex, who will be speaking on recent developments in the law of exclusion from refugee status. Geoff is an academic who I think needs little in the way of introduction, but I'll simply highlight a couple of the personal points on his very extensive list of achievements in the field of refugee law and human rights law more generally. Geoff is at present the head of school at the School of Law of the University of Essex, again one of the leading centres for human rights in the United Kingdom. He has been the editor-in-chief for the last 10 years of the leading journal in the area, the International Journal of Refugee Law. He took part in the global consultation, speaking again on the specialist issue of exclusion as part of the 50th anniversary of the 1951 Convention. More recently, he was specialist advisor to the Joint Parliamentary Committee on Human Rights regarding the treatment of asylum seekers in 2006-07, and in 2009, to crown his other achievements, he was elected as a bencher of Middle Temple Court in February 2010. So it really is a very great pleasure to be able to welcome Professor Geoff Gilbert here to finish off this, the last in our series of seminars.
I do like the term "finish off." I may well succeed. Right, exclusion, recent developments. It's but a few months ago that Professor Gilbert gave one of these seminars on Article 1FC. And, I should add, Article 1FC is the area of the 1951 Convention that's been receiving a lot of attention, which means that when I was looking at the title of this and looking for recent developments, the thought crossed my mind, should I just get Guy's paper out and just reread it, because everybody will have forgotten it anyway, because the attention span of most academics these days is about 20 minutes, and first-year students 5 seconds. So I was relying, and then Guy said he was going to come, which rather ruined that plan. Then David phoned me last week, and he said, got this project planned for 2013. Asked me if I would contribute my chapter on exclusion, which is a bit like sort of asking U2 to issue the 57th release of their song, or Tim Burton to release his film again. I mean, there is but one chapter on exclusion that's been done, and I've killed it. I was at a loose end. So the recent development is David's request, and this is not so much a work in progress as a work parked firmly on the drive, with me desperately looking for the map as to where I'm going to go next with exclusion. Because there's a lot being done, a lot being said, and I don't want to reiterate what I wrote 4 years ago, and then last year with a bit of new material. That's not what these seminars should be about. I was trying to find a new direction. So the intention is to explore issues that the courts are not fully addressing directly, but which might become problematic in the future when the particular scenario presents itself. I should add, I am deeply grateful to Professor Gilbert for sending me a whole load of bits and pieces in the last couple of weeks of stuff he's been doing, which I have shamelessly stolen, and means that if you've got any questions, ask him. Provide everyone with the background to the particular destination I'm heading for. I thought it would be useful to explain exclusion under the 1951 Convention as I see it, which might be summed up as too much international law, not enough protection. That might seem strange for an international lawyer, but it reflects 60 years of selective development in the 1951 Convention. It's often asked whether Article 1A2 would emerge in anywhere near as generous a form if it were to be redrafted today. I prefer to wonder whether, after all developments in international human rights law in the last 60 years, Article 1F would still be included, and for that matter, Article 33 too. It almost defies belief that a self-proclaimed humanitarian treaty that declares in the opening paragraph of its preamble its reference to the Universal Declaration of Human Rights, that it would now be thought correct that an individual who falls within the definition of a refugee would nevertheless be excluded. No one is excluded from human rights guarantees, apart from a few guarantees that deal with citizens' rights. How could anyone be excluded from guarantees against refoulement? Yet states cling jealously to their power in the 1951 Convention under Article 1F. And it was not ever thus. Before 11th September 2001, Article F was not a major tool in states' arsenals for refuting refugee claims made outside of Canada and the Netherlands. If you take a look at decisions from Canada and the Netherlands, which were incredibly generous in granting refugee status to start off with, you see at the same time that they were prepared to use Article 1F. Before September the 11th, 2001, it's not that 1F was not used. There are 1F cases, okay, undoubtedly. As an extradition lawyer, in my spare time, the leading case on the political offence exception under extradition law in the UK is a case called T in the Home Secretary, and T in the Home Secretary is actually a case under Article 1FB. Okay, so it's not that 1F was not used, it's just that 1F suddenly became, on the 12th of September 2001, sort of almost the starting point for people thinking about refugee status claims. It shouldn't be that, but the Security Council's repeated references to terrorism and refugee status in the post-9/11 resolutions 1368, 1373 and 1377 led to states having fresh regard to Article 1F and expanding it, aided and abetted by UNHCR's 2003 guidelines that correctly, if inadvisedly, pointed out to states that it is possible to interpret the 1951 Convention such that 1FA and 1FC can be applied to post-grant of refugee status activity. It's not wrong that 1FA and 1FC can be applied like that. Clearly the language of the treaty does permit it. Why UNHCR felt the need to highlight this fact escapes me on occasions, but we'll go there possibly later. As might be expected, early post-2001 cases did extend the scope of 1F, but there is some evidence that there is some retraction from the worst extremes. Gurung, which is included in the cases that went too far, did in its defence state that 1F should not be seen as simply an anti-terrorist clause. However, it did allow far too broad a concept of guilt by association, depending on the organisation to which the applicant belonged. Paragraph 105, the Immigration and Asylum Tribunal held that if the organisation is one or has become one whose aims, methods and activities are predominantly terrorist in character, then very little more will be necessary, which at the time coincided with UNHCR's 2001 guidance. Fortunately, UNHCR and the case law have moved on from that position, post-2001. We've had cases like JS, KJ, and we hope DD. But let's wait for DD to come out. The House of Law, sorry, giving my age away. The Supreme Court has some interesting cases coming up in the next. I'd like to. I was checking on the train. Has Al-Siri been sort of published today? And the answer is no, it hasn't. So we're still waiting for Al-Siri. We're still waiting for DD, but I think DD we're going to have to wait a lot longer for. So the first subheading, the first sort of question I ask myself is, are all war crimes called by Article 1FA? The reason I ask is because everybody knows that 1FD talks about serious non-political crimes. How many of you have got a law degree from a university based in the United Kingdom? Okay, did you do theft?
Yes.
Criminal law?
Yes.
Did theft, criminal law. So you know the 1968 Act, and you know that sort of the theft is the intention to permanently deprive another of their property. So going into your local Tesco's and half-inching, as I would say, a Mars bar, stealing a Mars bar, is a serious, well, it's a non-political crime. I do not believe that stealing a Mars bar could ever be a political crime. You might want to argue that if there was a famine on and the food was being kept for the ruling classes and you were not a member of the ruling classes, it could be seen, you could see the argument, but hey, let's not go there. So stealing a Mars bar is a non-political crime. I hope no one would ever claim that stealing a Mars bar is a serious non-political crime. But can you ever have a little war crime? As one of my friends said, can there ever be a little bit of genocide? It's not really on. So are all war crimes caught by Article 1FA? If you've committed a war crime, are you automatically excluded? Some correction. If there are serious reasons for considering that you have committed a war crime, are you excluded under Article 1FA? How much content in two monosyllabic words? War and crimes. Okay. It's much better defined now that one has Article 8 of the Rome Statute of the ICC. That makes it clear that war crimes can be committed in international and in non-international armed conflicts. And consequently, that war crimes extend beyond the grave breaches of the Geneva Conventions of 1949 and Additional Protocol 1. For those of you who have not studied the international law of armed conflict, the Geneva Conventions provide in all four that there are grave breaches which should be investigated, prosecuted, and, if necessary, because prosecution is impossible, the offender should be returned to a country that can prosecute. But that's only the grave breaches. But there are a whole load of other violations of the laws of war that are found not only in the rest of the Geneva Conventions of 1949 and Additional Protocol 1, but equally in Hague Law, which practically nobody ever looks at. Okay? Hague Law is fun. Hague Law is about means and methods of carrying out your armed conflict. And that's before we get into non-international armed conflicts. Conflicts that do not involve at least two states or a war of self-determination. And let's not go into what is a war of self-determination. So I grew up in a time where we all knew that there could be war crimes beyond the grave breaches, but it's only with Rome Statute that you actually get it clarified, and it applies to both international and non-international. Been known for a long time, but given 1FA's reference to international instruments as well as war crimes, crimes against peace, crimes against humanity, are we limited to Article 1FA? Is 1FA now subject to the definition of war crimes found in Article 8 of the Rome Statute? My answer to that is clearly not. Since not all states are party to the Rome Statute, and I'm assuming no one is yet claiming that Article 8 in its entirety reflects customary international law. That would be my position. So what is the overlap given the reference in 1FA to war crimes as defined in international instruments? For instance, for your edification, Article 27 of Geneva Convention 3 provides that prisoners of war shall be given sufficient underwear, making allowance for the climate. Would failure to do so constitute a war crime leading to exclusion under Article 1FA? So if you were the prison governor in charge of the prisoner of war camp and you did not provide sufficient underwear for the climate, would you be excluded from that moment on from refugee status? There are serious reasons for considering that you committed a war crime. You did not fulfil your obligations under Article 27. Are there less serious war crimes that do not give rise to 1FA? In JS, so there's one question. Do we need to nuance 1FA? 1FB is nuanced, we know it is. Is 1FA nuanced? JS in the Court of Appeal, JS in the Court of Appeal, which was endorsed at paragraph 8 of the Supreme Court, provided that the starting point for exclusion under 1FA ought to be the Rome Statute, but only the starting point. It doesn't say there's a direct correlation, it just says that's the starting point. The Court of Appeal also included the principles of criminal liability as set out in Articles 25, 28 and 30 of the Rome Statute. But anyone who's an international criminal lawyer in the room will tell you now that Articles 25, 28 and 30 do not cover the entire gamut of criminal liability as we understand it. It changes somewhere. Now, the Supreme Court broadened the extent to which joint criminal enterprise might apply by holding that voluntary contribution in a significant way to an organisation's ability to commit war crimes, aware that his assistance will in fact further that purpose, will suffice. Okay? So, the Supreme Court comes along, the Court of Appeal had been somewhat narrower on joint criminal enterprise. The Supreme Court comes along and says, actually no, here you go, this is the approach we want to joint criminal enterprise. And you can also take a look at the other tribunal in MT Zimbabwe, which is what a recent case, April, I think, 2012. I've got a problem there. The ICC has moved away from joint criminal enterprise. So all that case law that we have on joint criminal enterprise, which stems from the ISTL, we now have from the ICC, take a look at the Lubanga, in the pre-trial chamber, co-perpetration and indirect perpetration, and once you get to the actual judgment, then you're looking at concepts that are much closer to what in English criminal law we know as aiding and abetting. As Judge Fulford pointed out in his dissent, or separate opinion, it's not a dissent, in Lubanga, this concept of how far the ICC would go in looking at joint criminal enterprise is incredibly important. For those who do not want to wade through the 655 pages of Lubanga, or for that matter, the 2,500 pages of the Charles Taylor judgment from the Special Court for Sierra Leone. I mean, we have a phrase for that, it's called verbal diarrhea. One would not want the complexity of analysis of the ICC regarding joint liability, which meant not joint criminal enterprise, transferred to Article 1FA simply because Article 8 should be the starting point according to JS. What's the overlap between 1FA analysis and ICC analysis? If ICC is changing our understanding of how to interpret the ICTY cases now, are those cases that used ICTY analysis in Article 1FA hearings now going to have to be revisited? How much, and this is good, as you will see in a second, how much autonomous meaning do we need for the 1951 Convention? What is clear, by the way, just to give a little bit of information that so we can take away and put into a footnote, is that mere membership of an organisation will never suffice, and nor should mere presence. So take a look at cases like NH Syria, El Hayek in Canada, Jaoudi in Canada, or mere membership. Take a look at prosecutor and Bergevin, SK Zimbabwe on mere presence. By the way, sorry, I should also have added Barakzai and the RAT, which is an Irish case, on mere membership. So there's a whole load of cases now sort of saying, no, membership of an organisation, Gurin's starting point, is no longer the right starting point. So there's my first question, which I hope by the time February 2013 comes along, I'll have looked at in a bit more depth, as in what is this overlap between 1FA and the ICC? Is every war crime going to lead to exclusion? Are there little war crimes? I do not know. That brings me on to 1FC. An autonomous meaning for 1FC, I have. Autonomous meanings for terms in the 1951 Convention is the new catchphrase of lawyers, judges and commentators. As Lord Brown said in JS, though, it is to be found in international law, not national law. Footnote, Professor Gilbert. Okay. So when you're looking at autonomous meaning, it's the autonomous meaning in international law, not the autonomous meaning in national law. It comes to the fore in 1FC cases in relation to purposes and principles of the United Nations. The first thing to note is that it is no longer arguable that 1FC is limited to state officials. Okay, forget it. To be perfectly honest, it never was. Go and look at a case called Georg K. Okay. Georg K, I think I always get this the wrong way around, so forgive me. Georg K is an ethnic Austrian who was living in Alto Adige, South Tyrol in northern Italy, and went around blowing up, I think, electricity highways, if my research is correct, or he was doing something similar, okay, in the early 1960s because he wanted Alto Adige to be handed back to Austria. And he was excluded under 1FC, partly under 1FC, on the basis that he was trying to redraw the map, and this must be contrary to the purposes and principles of the UN. Okay, so redrawing borders is contrary to the purposes and principles of the UN. Therefore, he was small time. He was not a state official. So, what's there to discuss with 1FC? Well, it needs to be reiterated that not all violence is necessarily a threat to international peace and security. It may be an example of a group asserting their right as a peoples to self-determination. Now, David said he wanted me to talk for 45 minutes. I was thinking, I can't do it. Oh, I can. Oh, definitely. And all I need to do is start talking about self-determination. But if you take a look at the Charter, and I'm limiting myself at the moment to the Charter, okay, when we're talking about purposes and principles of the UN, okay, let's not go anywhere further than the Charter. Take a look at the preamble, which I think probably sets out some of the purposes and principles, and then Articles 1 and 2. Yes, maintenance of international peace and security is definitely a purpose and principle of the UN. And some violence definitely threatens international peace and security, so you could be said to be acting contrary to the purposes and principles of the UN. But please don't make that leap as an automatic leap. Just because you are violent, just because it threatens international peace and security, does not mean you're acting contrary to the purposes and principles of the UN. They are not necessarily the same thing. That's one jumping off point. Another jumping off point is to remind people that maintaining international peace and security is not the only purpose and principle of the UN. The right of peoples to self-determination is also listed in Article 1.3. Anybody with a copy of the Charter, please look it up and correct me later. Okay. So, if I am seeking self-determination for a peoples, whatever a peoples is, please note the right of self-determination is a right of peoples, not a right of a people. Okay. So much so that in the World Conference on Human Rights in Vienna in 1993, indigenous peoples went round with T-shirts that just had the letter S on, because governments were arguing about whether they should be called indigenous people or indigenous peoples. So they went and got T-shirts made up with the letter S on. So if you are a peoples seeking self-determination and using violence, are you acting in accordance with the purposes and principles of the UN? If you're trying to overthrow a dictatorial regime, if one takes a look at the Supreme Court of Canada in the Quebec secession case, cited regularly despite the fact it's not an international decision, but hey, let's go for it. So there's one problem I have. Which particular purpose and principles? If you take a look at KJ Sri Lanka, for instance, the Court of Appeal held that at the relevant time, the LTTE pursued its political ends in part by military action directed against the Sri Lankan armed forces, and that was part of the reason for finding that KJ was not necessarily excluded. I should also point out at this juncture another extradition case. It's one of the great advantages of being me is that I'm not a refugee lawyer, I'm an extradition lawyer who found refugee law later on in life. And so I know all the extradition cases, and there's a case which probably most in the room have never heard of, called Imri Atta, Ahmad and Wyden. It's a US case from about 1970s, early 70s. And Atta had carried out, allegedly, a terrorist act in Tiberias in Israel. Allegedly, please note. And Israel was seeking his extradition from the United States. And in extradition law, we have the concept of the political offence. You always wondered why refugee law talks about serious non-political offences. Extradition law had got in there about 120 years earlier with the political offence. Okay. And the political offence is an exception to extradition law. By and large, most extradition treaties say you shall not be extradited if your offence is political in character. Atta claimed that his act was political. The US Federal Court of Appeals, deciding the case, looked to see whether the act contravened Common Article 3. So their starting point was, if what is going on in Israel at the time is a non-international armed conflict, And if this would not be a violation of Common Articles 3, it would be a political offence. I should point out for the record that they held that this breach of Common Article 3, therefore they extradited it. Okay. But the reasoning is quite interesting. The reasoning is staggering given the US's other reasoning cases in the 1970s and 80s. Actually, no, it's not. I take it back. It's late 80s, early 90s. Okay. I don't know why. But the reasoning is absolutely staggering from the US court at the time, that an act which takes place in non-international armed conflict, but which is not in breach of Common Article 3, would be political in character. And you can see the arguments with DD that you can make along those lines. Very interesting. Compare that, though, with Gull, a case which is wrong at so many levels. Okay, but we'll come to Gull later on. Let's have a look at DD very briefly. We're waiting for the Supreme Court's decision. It's more complicated, but it's based on similar arguments at one level. DD, however, goes to a much more fundamental question with respect to 1FC. What constitutes a source of the UN's principles and purposes beyond Articles 1 and 2 of the preamble? Okay. It's going, obviously, if you're looking at purposes and principles of the UN, you start with those two articles of the Charter. Dead easy. What else? Clearly, not every Security Council resolution, and definitely not every General Assembly resolution, can give rise to a new or extended purpose or principle. It just cannot be the case. As Sir Michael Wood wrote in the Max Planck yearbook way back in 1998, at page 95, the Security Council resolutions are not treaties and have an essentially political nature. That is not to dismiss them or undervalue them, but to recognise that they are inherently different and should be treated with caution with respect to Article 1FC. To give an example already referred to in part, what of terrorism? The Security Council has repeatedly affirmed that international terrorism is contrary to the purpose and principles of the UN. And I probably agree with that. Okay? International terrorism is probably contrary to the purpose and principles of the UN. Excellent. Let me provide an example of a Security Council resolution that muddies the waters. 1440 of 2002, dealing with the Moscow theatre siege. The resolution never calls it an act of international terrorism, but equates it to international terrorism. Interesting. Okay. In paragraph 1. Now, without in any way questioning the seriousness of the attack at the Moscow theatre or its illegality, that's not an issue. It was about a group of Chechens in Moscow. Okay? That is, there is no obvious international character to the terrorism. It's a group of Chechens in Moscow. Where's the international element? I agree, international terrorism is contrary to the purposes and principles of the UN. Is domestic terrorism contrary to the purposes and principles of the UN? I think it's... These are... I mean, I think that if a 1FC case came along where somebody carried out purely domestic terrorism that had absolutely no international element, I can already see the questions, by the way, but weren't the Chechens partly funded by external sources? Doesn't that make it international? Aren't they seeking independence from Russia? Doesn't that make it international? Well, on that basis, Northern Ireland was international terrorism, for those of you who are from Britain. Okay, makes life a little bit more complicated. Okay. So, I don't know is the answer. This is the great advantage to this presentation. I don't know what I'm talking about. I will by next February. Okay, that's the deal. Okay, by next February I'll have much better footnotes. But I'm thinking now, I don't want to just regurgitate what I wrote. These are the bits that make me think, just think, how far can you go? If you want to exclude terrorism, by the way, use Article 1FB, not 1FC, it would solve everything. Why waste your time trying to fit it into contrary to the purposes and principles of the UN when it would be a serious non-political crime? It's not. Well, then we're going to come to what is political. And okay, I had a heckle, but a wonderful thing. To a certain extent, I like heckles. What's a political crime? Extradition Act back when. But in the same way there's no International Refugee Court, there's no International Extradition Court. So one is forced, when trying to understand political offences, to look at the decisions of domestic courts. And various approaches have been adopted towards the political offence exception. This goes again to sort of where are we going with 1FB, but I'll do that in a minute. The initial, my starting point is always the US approach to the political offence exception, which is by far the broadest. Okay? The US approach is, are we talking about an act that is part of or in furtherance of a political uprising? That's the US approach to the political offence exception. You've got to have a political uprising, it's got to have reached that level, and it's got to be part of or in furtherance of. Two cases quickly to explain. One is called Quinn, and that way the US magistrate was in San Francisco. But anyway, Mr. Quinn had been in London. He was part of the Spaghetti House siege in the 1970s in London. He had killed a police officer in central London in escaping. He was then discovered in California. The UK sought his extradition. The US, his claim was, I'm a member of the IRA. The IRA is fighting for the independence of Northern Ireland from the rest of the United Kingdom. My offence is political in character as a consequence. Okay. And I have to say, if you take a look at US decisions from the 1980s dealing with IRA cases, that argument, generally speaking, worked. Okay. In that particular case, the Queen case, what the extradition court in Northern Ireland found was that there was no, in San Francisco found, was that there was no political uprising taking place in London. There was a political uprising in Northern Ireland, but not in London. I lived in London in the 1970s. I remember not going into central London at certain times because you knew that there might be a bomb going off. Okay? It felt like a political uprising at some times to me. But the US court found there was no political uprising, therefore his crime could not be political in character. It was as simple as that. Got a political uprising, crime's part of it, you are got a good example of just how far it goes the other way. Artukovic is a case from, again from California. They also gave us Squeaky Fromm and Richard Nixon, if I remember right. But anyway, Artukovic case involved the former minister, Croatian Minister of the Interior in the Axis government from the 1940s, in the former Yugoslavia, in Croatia, sorry. And they actually had his name on 1,200 death warrants, so he was probably associated with about 30,000 deaths. The US court found in part that World War II was a political uprising. His crime had been part of World War II, and therefore it was a political offence. Yeah. So you can see how far the US approach went at the time. There was a later Artukovic in 1984 where the US retracted on its rather extreme understanding, but that's not part of today. The UK approach sounds similar. It's got to be part of and in furtherance of a political disturbance. So you don't need an uprising, disturbance will do, but it's got to be part of and in furtherance of. And they built in a remoteness test over time. It can't be too remote from the ultimate goal of the organisation. So you begin to see that, so the US approach to serious non-political crime might be different from the British approach to serious non-political crime. Later, a different approach is the Swiss approach, which again uses the part of and in furtherance approach, i.e. the remoteness test, but they add in a proportionality requirement as well as Swiss. So even if it is not too remote, it can't be disproportionate, which is why most terrorism gets excluded because it's disproportionate violence. And the UK adopted the proportionality approach in Madam Secretary. The Irish equally adopted the Swiss approach in a case called Miglici and Wren. And then the Irish added in another element to their interpretation of the political offence approach, which is that it can't be your crime cannot be a threat to the requested state in as much as it was a threat to the requesting state. So this idea that you can't be seen as someone who is a threat to all states, which we'd all recognise anyway from the cases dealing with anarchists at the beginning of the 20th century. So our understanding of political crimes, is different across the world. And the US approach is therefore going to have a broader understanding of what is a serious non-political crime than the UK adopting the Swiss approach. So there's a problem with 1FB. How much should 1FB follow extradition law? Should we have an autonomous meaning for serious non-political crime? Or should we try and follow the political offence exception? Because that's a war, I promise you. It's crazy. That brings me to proportionality. This will be short. I've lost. Basically, I've argued for proportionality for years. I've lost. We keep on being told that the 1951 Convention is a living instrument with a humanitarian object. Yeah, it might be living, but it's definitely on life support. Yet when it comes to Article 1F, the plain meaning of the text, without any context, is the rule. Even when IH Eritrea has upheld the purpose of approach. Okay? Surely, if international human rights law has developed in the last 60 years, and there is nothing on the face of the ICCPR or ECHR that prevents reform, read them from beginning to end, nothing there, they both sort of incorporated it, then international refugee law cannot behave as if non-reformal is not a binding principle that is always claimed when the excluded person would fear for his life or freedom if returned. I mean, it's contrary to my understanding of what a humanitarian treaty is about, that you can exclude even when the treatment the person would receive on return is so horrific that human rights law is going to step in and protect you. But I'll get to that in a minute. Okay. Even international criminal law treaties prevent extradition if the alleged fugitive fears persecution or punishment based on race, religion, political opinion or nationality. So if international criminal law protects you, why doesn't international refugee law protect you? Okay, nevertheless, despite the eminent perspicacity and scholarly insight of the German Federal Administrative Court in reference of B&D to the ECJ, the latter court held that proportionality plays no part in determining exclusion. Thank you, the ECJ. In the alternative, therefore, might I suggest reliance on Professor Goodwin Gill's resuscitation of the principle of humanity, okay, in international law based on the Corfu Channel case. I like it. I hope it can be taken further. By the way, coupled quite obviously with the obligation to prosecute the person granted refugee status in such cases. Okay? So if you don't exclude based on the treatment the person's going to receive, you have an obligation to prosecute. Okay? Take a look at cases like the Hungarian deserter and the Austrian universal jurisdiction cases from extradition law. Take a look at the concept of aut dedere aut judicare. Okay? It is not impossible in the 21st century to allow for the prosecution of crimes that you find excluded in 1FA and 1FB. Forget 1FC, it's really okay. That brings me on to IDPs. Just a minute, what are they getting? I like IDPs. In proportionality, it's implicit, but no one. But once one has regard to IDPs, this issue becomes crystal clear. Proportionality is not needed when the judges know that the applicant can always rely on the European Convention on Human Rights or the International Covenant on Civil and Political Rights, okay? To provide a safety net that's generally effective. Take a look at Sardi in Italy, take a look at Suffi and Elmi in the United Kingdom. However, most displaced persons have no access to such procedures. Is there an obligation, therefore, to apply the 1951 Convention as if the safety net did not exist, lest case law from Europe or North America might condemn someone who is outside the guarantees incorporated through human rights? I have a great problem when judges in Europe and North America say, okay, we can exclude, secure the knowledge that international human rights law is going to protect them. Yet when you look at the vast majority of people who are displaced, they are not going to be able to rely on the ICCPR or the ECHR. So if they get excluded, they're going back.
Sorry, I'm being obtuse. I thought IDPs weren't outside their own.
No, IDPs, I'm just using this as a sort of a, IDPs, if anything, this paragraph is the connection between the last paragraph and this paragraph. IDPs is this idea that we're dealing with human rights, we're not dealing with refugee law. When you come to IDPs, you get a similar sort of dilemma, okay? The nature of mass displacement. Some displaced persons will cross an internationally recognised border, but others won't. This was never previously a problem, but with the guiding principles in UNHCR's extended mandate to conflict IDPs, the contrast could not be more stark. UNHCR might be dealing with a mixed population and have to exclude under paragraph 70 of its statute those from across a border, yet extend protection to IDPs with respect to whom there are serious reasons for considering that he or she has committed a war crime, crime against humanity, or crime against peace, serious non-political crime, or is guilty of acts contrary to the purpose and principles of the UN. That's why that paragraph fitted in both the conclusions of the previous section and this section. To be sure, Principle 1.2 of the Guiding Principles states that the guiding principles are without prejudice to individual criminal responsibility. But that does not deny the internally displaced génocidaire from the relevant guarantees of Principles 2 to 30. No one says, I'm sorry you've committed genocide, we're not going to give you protection. And UNHCR, that is now mandated to deal with the protection of conflict IDPs and manage camps for conflict IDPs, could be in the invidious position of saying to those who cross an international border, sorry, but to the IDP, here, don't worry, macheting with blood still on it, don't worry, just sort of clean it off under the tap over there. Yes, I have a sixth sense of humour, David was referring to it earlier. I once made that comment, looked up and saw that directly opposite me in the seminar room in Essex was a Rwandan Tutsi. And he laughed his head off. And I thought, that was close. Anyway, back to this. Okay. To be sure, right. which way should we lead? Should we force UNHCR to act as the police and hand over any IDP suspected of an exclusion crime to the state, or, relying on Principle 3 of the Guiding Principles, cast the duty to find and arrest the génocidaire, who is internally displaced, onto the state that is responsible for humanitarian assistance? There are clear consequences for UNHCR and its role in refugee camps from paragraph 70 of the statute. So you look at the ex-cons and UN Security Council Resolution 1208. Do they implicitly affect the management of camps for and the protection of conflict IDPs? Conclusion. What's the Supreme Court going to say in Al-Syria, in DD? I don't know. They're a weird bunch on the Supreme Court. Do we now expect every 1F case to focus on the latest emanations of the ICC? Is that appropriate? Is refugee law being overrun by international criminal law and international law of armed conflict? Hence the reference right at the beginning, too much international law, not enough protection. The Court of Appeal in Gull criticised the analysis of international criminal law in 1F cases, but then got all the international law wrong it possibly could. If you want a bad decision by judges claiming to understand international law, trust me, read Gull. Yeah. Do we need an international refugee court? One that can provide coherence and oversight rather than relying on a bunch of courts that are not specialists in refugee law to try and explain what is undoubtedly one of the most complex provisions in international humanitarian law, Article 1F. The idea that you can say to someone, yes, you have a well-founded fear of persecution, your life or freedom would be threatened, but we're still sending you back. "40 minutes, not bad."
Well, thanks for what was a very thought-provoking paper. I'm sure that there's a number of questions that people would like to, or comments that people would like to...
And corrections.
...to make. I just had one that I was going to take you up on, and I'll use my position as chair to do so. When you're talking about this IDP and refugee problem that UNHCR has, I wonder if the problem doesn't lie elsewhere. I mean, it seems to me that UNHCR may well have a mandate for conflict-affected IDPs.
Yeah.
Doesn't conflict-affected imply affected in the sense of a victim as opposed to being a perpetrator in the conflict? Or does it extend to combatants as well? Because you start to get on some slightly difficult questions there. I suppose treading on the steps of all sorts of things about the management of civilians, combatants in refugee camps. But my point is a slightly broader one. And that is, I think that the problem surely is that the development of UNHCR's mandate creates problems for UNHCR on the other side of the border. Because originally UNHCR had to exclude those individuals for whom there were serious reasons for considering they committed excludable offences.
Yeah.
Surely now with the expansion of UNHCR's mandate to protect rejected asylum seekers, almost anybody who's crossed the border, is there not some kind of conflict there where UNHCR now has, on the one hand, an obligation to exclude those persons, but given that they still face some form of persecution, its extended mandate gives them protection duty towards those? Isn't that where the real conflict lies, rather than between IDPs and refugees?
About three sections to this response. I'm just going down to that. Right. Starting point, UNHCR has always had a problem in camps, in conflict situations, You go back to the 1980s, early 80s, Thai-Kampuchean border, okay? And you had a whole load of Kampucheans, I think they probably were, Khmer Rouge, okay, forced into Thailand by the Vietnamese arrival. And they basically put themselves in these camps that UNHCR was initially running. And they were using them as a base from which to attack the Vietnamese, who were now back in what was then Cambodia. UNHCR basically got itself out of that mess because the UN set up UNRWA, the United Nations Border Relief Organisation. And UNRWA ran the camps close to the border, and UNHCR ran at least one camp, maybe more, about 5 miles back. Okay, that was dedicated to people who said, right, no, we're not fighting, we are claiming refugee status. So UNHCR does know how to sort of exclude itself from this dilemma, okay, if the UN can sort of help. You go forward about 10, 12 years from that, it is one of the delights of sort of having taught some of the people who then went out to deal with Rwanda. And I still remember sort of, there was a group of Essex graduates based in various camps in Tanzania and what was then Zaire. And they said, we were always surprised. All these young men who got up early every morning in the camps and they do exercises together. Now, one of the biggest problems in refugee camps is sort of lassitude and sort of not having enough to do and sort of how to... And sort of, here were these young men getting up every morning and they exercise together and train. And then one night they all vanished. And that was because they were using UNHCR's camp as rest and relaxation from fighting, and they were into Hanway. And it was, so UNHCR suddenly thought, oops, and then get into camp separation, all those ideas. So I think there is always going to be a problem for UNHCR in dealing with camps because it cannot exercise 7D effectively in a massive flux situation. And all you need to do is, if you've got your AK-47, basically dig a hole about half a mile from the camp, throw your AK-47 in and walk into the camp and say, I'm a refugee, okay, which is basically what they would have done. Equally, the second part is that you take a look at the Great Lakes region and you have mixed camps in the Great Lakes region of people displaced across an international border who are, and I'm not talking about fighters here, I'll focus entirely on the sort of the civilian victim for a second. So you might in that one camp have both civilians who are being displaced across a border and civilians from a conflict taking place within that state. So truly mixed camps. It doesn't take much imagination to say that some of the people in there might at some point have been involved in the conflict. At what point do you stop being a combatant? Your own research in Colombia, okay, leads you to know that there's a whole load of stuff there that goes about sort of, are you a member of 24 hours a day?
The revolving door.
The revolving door question. And can you walk into a camp at the moment when you don't have your weapon with you? Okay? And yet, this takes me back, and it's an issue I didn't deal with because I think it's probably been done enough, but hey, let's wait for the case. Propitiation. There is no propitiation in Article 1F. Technically, there are cases that discuss this, Canadian cases, generally very generous, UK cases not quite so generous. Basically, if the serious reason for considering that you have committed a war crime is that you spent 20 years in jail for committing a war crime, technically you are still excluded. So it's a very serious reason. You've got a conviction. I can therefore see that there are issues, obviously, if we had as many refugee status determination officers as we needed in camps, carrying out individual status determination as the people arrived. Okay, paragraph 70 of the statute could be resolved. But paragraph 70 is never going to be resolved. It's going to be a mess. Start mixing in IDPs. Start mixing in people who are victims at the time that they have to flee, but possibly weren't a victim a week before because they were firing. How far you go back, a week before, a year before, 20 years before, and you get into problems which, by the time next February comes, I might have thought this through a bit further. But you can see it's not straightforward to just say, hey, isn't the management of, don't you mean by IDPs, persons who are victims? Perpetrators of war crimes can also be victims. Okay, that brings me back to the issue of what's the solution? Is it to just sort of say, right, well, we're going to exclude you and ignore you entirely, or we're going to protect you, but part of protecting you means we're going to prosecute you? I mean, one of my biggest problems with 1FA, 1FB, and 1FC is that it allows states to avoid their responsibilities in relation to international criminal law. You exclude someone, you don't let someone in, and your génocidaire therefore walks away and you don't have to deal with the génocidaire. He's abused his privilege.
Okay.
Your turn to
Having done so, any questions or comments people would like to add?
Sorry, Professor Gilbert, I thought I'd missed a great deal of that. Sorry,
that's why you're still awake.
Well, I work for the UK Border Agency.
Right, okay.
I'm responsible for giving guidance on exclusion. So I'm really sorry to have missed what you said. But going back to just that comment just now about the génocidaire, well, the UK did hand over some, or at least one, is that right?
Yeah.
To the international.
Oh yeah.
But we would have done more. They would have gone back to Rwanda if we'd had the assurances about trials and stuff.
There is a world of difference between handing over to the ICTR and handing over to Kigali. That's not what we're discussing here. Equally, there's a case called Zardad. Mr. Zardad is currently doing 20 years at Her Majesty's pleasure. Mr. Zardad is an Afghan. Before the invasion of Afghanistan, his main trade was kidnap and torture on the road between Kandahar and Kabul. He basically did this with respect to other Afghanis. Okay? After the invasion, he decides business is not going to be as good as it was, so he relocates to London. Okay? As is the nature of UK Border Agency, probably providing the statistics on this, the nature of displaced persons, refugees, I include in that, is that they tend to congregate in certain parts of the host country. Okay, so I think you've got a whole load of Somalis up in Sheffield. Okay. There's also, for those of you who go to any US nationals in the room, I've always thought it weird that there is an enormous Somali Sudanese population in Minnesota. Of all the cold places on the planet, they are congregated there. Anyway, Mr. Zardad relocated to South London, where there was a large Afghani population, some of whom recognised him. He was reported to Scotland Yard. Scotland Yard investigated. He was put on trial at the Central Criminal Court, and he is currently doing 20 years based on Section 138 of the Criminal Justice Act, so 134 of the Criminal Justice Act, 1988, for torture in Afghanistan perpetrated against other Afghanis. There is no UK connection with the case other than the fact that Mr. Zardad turned up in the UK. If the UK border agency is not sending people back to Kigali, and I probably agree with that, okay, and the ICTR is being closed down and therefore won't be dealing with these cases, and the ICC has no jurisdiction to deal with these cases, then I think it is incumbent on the DPP to consider how far we can prosecute when evidence comes to light in the UK Border Agency's investigations. The nature of criminal evidence rules in the United Kingdom, I used to teach evidence to undergraduate students, and I only have to say hearsay to certain students and they still quake, means that prosecuting persons for crimes committed outside the UK when you do not have a percipient witness in court to be cross-examined makes life difficult. But yeah, my view would be exclude happily. But if you are not going to send them back, okay, prosecute them. And in the UK, I'm pretty certain that persons excluded will get protected under the ECHR where it's appropriate. So that should be our response. Okay. I would prefer it if they weren't. If exclusion could move on, if we started looking at likely treatment, in other words, if there was a sort of moral fusion between the human rights guarantees and the 51 Convention. If human rights happen, why not the 51 Convention? Question for you. Article 8 of the European Convention on Human Rights has got nothing to do with what I've been talking about. But it's an example to make you realise that how far human rights have moved on and how far refugee law hasn't. Article 8 of the European Convention on Human Rights talks about a right to a private life, home, that one, correspondence. I am pretty certain that when the drafters back in the late 40s were drafting the European Convention on Human Rights and they looked at Article 8, they were thinking of the way the Nazi government in Germany had not respected people's rights to security in their home, their correspondence. That was what they thought Article 8 was dealing with. Article 8 is the way for a transgendered person in the United Kingdom to obtain, well, it used to be, now there's a proper statute dealing with it used to be the way for a transgender person in the UK to obtain fresh documentation on birth certificate indicating their new gender, that confirms the gender. I can promise you now, not a single drafter of the European Convention on Human Rights ever thought that that's what Article 8 would do. If human rights develops, why not 51?
Okay, but to be fair, women weren't included in the Refugee Convention as a particular social group, and they are now. I mean, it's moved on to that stuff. And homosexuals and that part of it has. Anyway, what I wanted to ask you about was not that. It's about serious non-political crime. In the UK, and I don't know about other countries, so you can tell us perhaps, the definition of particularly serious crime became a statutory definition in 2004, I think it was. And it embraced, for the purposes of Article 33(2), and it embraced everything from genocide to shoplifting or vice versa.
Because basically, if you've had a 2-year sentence, 2-year prison sentence, or 3 year.
It was either a 2-year sentence or it was being convicted in relation to one of the designated offences, including all the Theft Act offences, including criminal damage.
Stealing a Mars bar.
It was stealing a Mars bar, exactly. And since that was defined as a particularly serious crime, until actually the Court of Appeal, I think in EN Service, said that is ridiculous, it must also have affected I would have thought the way that a serious crime, it must have had a sort of trickle-down effect in the way that what was a serious crime. So the trivialisation of particularly serious crime for Article 33, and it goes back to what you said about actually needing an autonomous meaning. And I don't know whether there's been any recent law on what constitutes serious in terms of the Article 1FB.
Can I turn to the person sitting next to me on all the case law that's relevant to this? I can't think of any either off the top of my head.
I can't think
1FB.
For 1FB?
For what? Well, basically what serious means. Or, for 1FB.
Can I help?
Yeah, please feel free.
I'm Amanda Weston. I was counsel in the case of AH, in which the Court of Appeal recently declined to deal with that issue.
Yeah.
We put in your paper on exclusion, the UNHCR background note.
Yeah.
And they were very interested. Sullivan was particularly interested. He wanted to deal with it. And the context in which it came up was in the context of a conviction under the notorious Association de Malfaiteurs in France. So they were very much, this was a series of convictions which are notorious for their unfairness, basically a crime of association. And the Court of Appeal was asked to consider all the circumstances surrounding the conviction rather than the fact of the conviction. Because going out to what Fran just said, part of the problem about the definition of the domestic states defining particularly serious crime is that it's the wide definition which is given to terror-related crimes. So once it's become sufficient just to say terror-related, and then it meets the definition, regardless. And in this particular case, the sentence was under 2 years, and it included 6 months for a document offence, which was not terror-related. So one of the reasons I came on the scene is I'm really interested to hear what you had to say about that. And because, of course, the tribunal, the matter's been remitted, and the upper tribunal is going to have to grapple with what serious means in the context of Article 1FB and terror particularly.
It goes back to what I was saying right at the beginning. There are all war crimes automatically excluded under 1FA. Can you have a little war crime? Because, I mean, and I gave the example. Sorry, I saw you arrive, but I don't know what point. The Article 27 of GC3 talks about provision of sufficient underwear to prisoners of war. Okay, failure to provide sufficient underwear to prisoners of war is a breach of Geneva Conventions. Technically, it could be a war crime if you're the prison governor. Is that going to exclude you under 1FA? And the answer is, well, I'm assuming that there might be other things that you're doing that are worse than that. It will be interesting to see. My problem with 1FB and serious is that it's very rarely been discussed. The big issue's always been, is it political, is it non-political? And then the sort of, for me, the rider has been, well, it's not every non-political crime, it's got to be a serious non-political crime. And it only tends to become important when you've got a whole string of crimes, some of which are serious. And I cannot think off the top of my head of any 1FB case anywhere in the world that wasn't serious. So I'm turning to someone who's got 800 cases extra in his third edition.
Now, what I could mention is that incidentally now Syria, even though it didn't involve Article 1FB, Council for the Secretary of State, Tim IQC, argued in effect that it was up to every state independently and autonomously to decide for themselves A, what was a crime, and B, what was serious. So that's the direction that the argument will go. I must say that argument wasn't particularly well received by the judges, but I mean, nonetheless, that was the basic line. There was no, therefore, international content worth mentioning in either of these terms.
I think there was an issue of, in AH, Algeria, there was an issue of sufficiently serious. So they rejected the idea that it was for the Secretary of State to define, each state was to define domestically what serious means. And they went for they said there was an autonomous meaning.
Yeah.
But they were particularly fixed on, and this is where it all started to go a bit too complicated, so they batted it off to the tribunal, on the difference between the French version of the convention and the English version. Because the meaning of a crime in French means a serious crime,
yes.
Whereas of course it has a more generic meaning in English.
I'm sorry, I can't help. Other than to say, I await the decision.
Perhaps this is something we'll keep an eye on as things develop.
Any chance it will come out before February?
No, I think they haven't. The tribunal haven't heard it yet. You probably will have an involvement, even if it's only in paper, on paper.
That is the nature of being an academic, searching for your own name in Lexis. It's called impact, but don't go there.
On that, any further questions or comments? Perhaps whilst you're thinking, there's one thing which occurred to me is that you haven't talked very much about serious reasons for considering. And people tend not to talk very much about that. There's not a great deal written on it as far as I can see.
That's the Michael Bliss article.
There is, but my question went towards something that we were talking about at a workshop in Article 1F a couple of weeks ago in Canada. And this is the question where, in Canada, things seem to be getting increasingly criminal in nature in the application of Article 1F. And the question was raised by some of the practitioners there, whether or not criminal guarantees, criminal procedural guarantees, shouldn't apply, where Article 1F was raised in the refugee context. And one of them had actually quite a neat argument, which was that the Inter-American Commission, in their report on the USA detention procedures, etc., or immigration procedures, has chosen to take deportation as effectively being a criminal sanction, such that where deportation procedures are effective, and one could, I think, draw an analogy where exclusion is applied to refugee cases with a view to removal, etc., that there might be some argument for the application of due process guarantees which would apply to criminal trials.
I've waited on about this in the past. First of all, the Inter-American Commission is my fault. I argued a case before them several years ago now, dealing with the Chilean who has Garcia Lopez. And I still don't know why they were so interested in the refugee point. It was wholly irrelevant to what they were discussing, since he wasn't a refugee. But they really got excited about refugee law, and they therefore said, how can we use this? Discussion about it. Right. The bit that interests me, this is not to answer the question about what the serious reasons for considering. I actually think there have been quite a few cases lately that have mentioned sort of how much evidence is required by a whole load of cases. But can I take you on a slightly different route, which sort of ties in with what you went on to talk about in Canada? As we all know, Article 6 of the European Convention on Human Rights does not apply to refugee status determination agreements, according to the European Court of Human Rights. I'm not certain they're right on that, but let's say that's their starting point. On the basis that it is not about a civil obligation or a criminal offence. My ECHR was not right. I had thought for years that the Human Rights Committee, because the wording of Article 14 of the ICCPR is different, would say, yes, we can deal with these issues once they were brought before them. Because Article 14 is much broader in its language. And then along came General Comment 32, in which they actually said, no, we're not going to deal with it. And I was most irritated. So both the Human Rights Committee and the ECHR said, we're not going to deal with. Okay. However, this is when we come to exclusion. And my view is that when you're dealing with exclusion from refugee status, which is based on serious reasons for considering that you have committed a war crime, crime against humanity, crime against peace, serious non-political crime, or you're guilty of acts contrary to personal matters of the UN, that is dealing with a criminal obligation. And you can take a look at cases like Engel and the Netherlands, which is a case from very early on in the ECHR, in which, again, autonomous meanings, they said that criminal has an autonomous meaning for the European Convention on Human Rights. I don't think they used autonomous meaning, but that's effectively what they did. And they said that an administrative decision dealing with a soldier was effectively a criminal sanction. So my argument might be, in relation to your question about what the serious reasons for considering that, that when it comes to exclusion cases, it has a sufficiently criminal character that it should invoke Article 6 of the ECHR. So in other words, the hearing should fall within the rules as set out for the hearing should look like in Article 6, and possibly Article 13 on effective remedy. Going back to your question as opposed to what my answer was, which wasn't the answer to your question, what serious reasons? Sorry, because I've prepared this paper, I've forgotten all the relevant cases, but there have been a couple of cases lately, and I was reading at least two of them for this, so it must be cases like El-Siri and SK and MT that have dealt with the amount of evidence that you need in order for someone. Because I think there's also is it MT in Zimbabwe, the case that came out from the tribunal, the crime against humanity based on a police officer in Bulawayo. I think it's MT in Zimbabwe, in which she's a very small fish in the system, but she has been excluded because she was definitely aware when she was a serving police officer in the Bulawayo Central Criminal Station that opposition figures in Zimbabwe were being mistreated when they were arrested, and therefore they're excluded on that basis because there are serious reasons for considering that.
Wasn't that more about the scope of commission or abetting or etc. rather than the evidence? I mean, that's how widely you cast the net. She was present.
Yeah, but she knew about it. It was more than she was just aware. She didn't do anything to stop it. But I think there's also discussion in that case about how much evidence you need in order for someone to be brought up. And that's definitely true of several of the cases that are currently going through. Do you think what?
In Al-Siri and DD, which were joint cases, UNHCR did intervene, and Mike Ford QC was their counsel, and he did address the issue of the interpretation of serious reasons for considering. The problem, just to go back a bit with the Canadian idea, of course, is you have to work within the terms of the treaty, and it's easy enough to come up with nice, ideal alternatives to the words of the treaty, but any court is going to hold you back to remind you that what they have to do is interpret the terms of the treaty, not your ideas about democracy and the rule of law. And if you're going to try and change the words, the meaning of the words of the treaty, you're going to have to show practice between the states, or perhaps under Article 31, little 3C, the applicability of relevant rules of international law between the parties, which is hard enough. So UNHCR, to go back to their intervention, working within the treaty, has obviously tried to breast the common law, civil law traditions and come up with an interpretation of what serious reasons considering means, bridging those two traditions which govern between many of the parties to the treaty. I can't for the life of me now remember what alternative words he came up with. It was a variation on what English courts have adopted, which is to say well, it's not proof beyond all reasonable doubt that's an issue. It's not balance of probabilities, it's something in between. It's more, as Stephen said, they said more than mere suspicion. And then they're generally cried off by saying we can't put any more glosses on the words, let's try the best as we can. And I think that's the way that the English courts have done it to some extent. They have taken the evidence and decided, in the light of these general assumptions, that it's not proof beyond all reasonable doubt, it's not balance of probability, but something else, whether on the weight of the evidence this is a person who ought to be excluded. I mean, they have been very keen to emphasize that there must be evidence to show that someone is excludable, not mere suspicion. But beyond that, they have, like the well-founded theory, very often, I think, tended to hold back from trying to reduce the full into any more particular form of words. But I think for the latest UNHCR pronouncement on that, you look to Mike Forden's intervention in now Siri DD.
Any last questions or comments to round off? Well, dot of 7 o'clock. Thank you very much again to Geoff Gilbert and to all of you for your participation today. And I wish you very happy times over the summer. Hopefully see you back here in October. Thanks again.